Good morning. Before we go on the record, we're just going to go over a few administrative matters. In terms of opening statements, are the parties going to make opening statements? Ms. Gonzalez? Yes. Mr. Miller?
Yes.
Ms. Gonzalez, in terms of your client, Ms. Pierce's testimony, during the telephonic pre-hearing conference, we discussed three manners in which Ms. Pierce could testify: via direct examination, via testifying in a narrative fashion, or reading from a prepared statement, or any combination thereof. My question is, will Ms. Pierce be reading from a prepared statement?
She'll be paraphrasing.
Since she's technically not going to be reading from her prepared statement, we don't need to exchange copies of that prepared statement in advance. Okay? No, we do not need to read.
We do not,
that.
okay.
No. But from what I'm looking at, is that what was marked as Exhibit 9 for identification?
Yeah.
Just to be clear, okay. And all the parties, I'm sorry, FTB and the panel, we did receive copies of Exhibit 9, which is not admitted into the record as evidence, and I'll get to that momentarily. Before we go on the record, are there any questions from either side? Hearing none? Okay. In that case, we are ready to go on the record. We are on the record in the matter of the appeal of Monique Renard Pierce, OTA case number 18-010967. This hearing is taking place in Sacramento, California, November 18th, 2019, and the time is approximately 10 a.m. The panel of administrative law judges consists of Tommy Leung, Sarah Hosey, and me, Alberto Rosas. And although I may be the lead administrative law judge for purposes of conducting this hearing, please note that the three of us, this panel, we are all equal participants, equal decision makers. At this moment, I'm going to ask each of you to please state your name for the record. We're going to get started on my far left.
Melissa Gonzalez, representative from Renard.
Brian Miller for Franchise Tax Board.
And Sonia Woodruff for the franchise.
This hearing is being recorded. We do have a stenographer, so I'd just like to remind each of you to please speak slowly, speak clearly, and please speak one at a time. We did have a telephonic pre-hearing conference on October the 30th, which resulted in my issuance of 5 orders. I'm just going to go over those orders. Number 1, appellants exhibits 1 through 8 were admitted into evidence without objection. Appellants exhibit 9 was not admitted into evidence. Number 3, respondents exhibits A through H, that's Alpha through Hotel, were admitted into evidence without objection. Number 4, we agreed that only one witness, Ms. Pierce, would testify at today's overhearing. And lastly, we also agreed that the parties would comply with specific time limits, and we estimated that today's hearing should take no more than 1 hour. Ms. Gonzalez, is this an accurate summary of the pre-hearing conference orders?
Yes.
Mr. Miller?
Yes, it is.
At this point, we will begin with opening statements. Ms. Gonzalez, you have up to 5 minutes, and you may begin whenever you're ready.
Thank you. We're here today to appeal the Franchise Tax Board imposition of an additional tax of $3,359 on Ms. Pierce's 2012 tax returns. In 2012, Ms. Pierce worked as a sales representative for McCarthy Building Corporation. Ms. Pierce did not work at the corporate office. She worked at a small subdivision of the corporate office in Roseville, California. Her duties as a sales representative included traveling to meet with potential clients and eating with them with the hope of securing business contracts. This was a standard practice of sales associates, and Ms. Pierce's travel to meet with clients, to secure construction contracts was what all sales representatives practiced in their capacity as sales representatives. Both the Franchise Tax Board and Ms. Pierce agree that the reimbursement policy of McCarthy Corporation was to reimburse for all business-related expenses related to the acquisition of construction contracts. However, as Ms. Pierce has stated and will testify today under oath, the Roseville office practice of reimbursement was not consistent with corporate policy. Instead, the Roseville office only reimbursed for travel expenses that related to construction contracts. There are two issues in this case. One is whether Ms. Pierce can establish an allowable unreimbursed employee expense deduction, and two, whether she can substantiate those amounts. With respect to the establishment, Revenue and Taxation Code 17021 permits employees to deduct business expenses that are ordinary and necessary to her employment and that are directly related to or pertain to the employment. Ms. Pierce's duties included traveling to meet with clients, and she would incur travel and meal expenses. Therefore, these expenses were in the ordinary course of her employment and were necessary as a precursor to the ultimate hopeful step of securing a construction contract. With regards to the substantiation of the amounts, Internal Revenue Code 274D requires employees to substantiate their business expenses that directly relate to or pertain to employment. Ms. Pierce has the burden to substantiate these expenses either through adequate records or sufficient evidence. Ms. Pierce's original receipts that she used to file her 2012 tax returns were inadvertently lost 2 years after she filed her taxes. And so, in response to the Franchise Tax Board's request for information to establish and substantiate her amounts, she provided credit card statements in Exhibit 4 and her calendar, and also compiled a table of calculations. And this evidence includes the amounts claimed as deductions, descriptions of the amounts, for the business purpose of securing construction contracts, and she has established the business relationship as the taxpayer to the person or entity that receives the benefit of the travel expenses, in this case being McCarthy. McCarthy benefits from the travel expenses that she's claimed.
Ms. Gonzalez, you have approximately 30 seconds, so if you can begin wrapping up your opening statement.
I have concluded my opening statement. I'm ready for Ms. Pierce to be sworn in.
Thank you. We'll get to that momentarily. At this moment, Mr. Miller, would you like to begin with your opening statement?
Yes. The evidence would show that appellant did not request available reimbursement from her then employer. For this reason alone, she is not entitled to deduct her claimed unreimbursed employee expenses. Appellant contends in her briefs that she did not seek reimbursement because she thought her office may close or she could otherwise lose her job. However, under California law, employee concern with an employer's financial condition or even her own employment security does not excuse the legal requirement to seek reimbursement available from the employer. Simply put, appellant did not seek available reimbursement and is not entitled to deduct her claimed expenses as unreimbursed employee expenses. This concludes my opening remarks.
Thank you, Mr. Miller. At this moment, we're going to begin with witness testimony. Ms. Pierce, if you wouldn't mind taking a seat in the witness box. And actually, before you sit down in the witness box, just remain standing. Our stenographer will administer the witness oath.
Please raise your right hand. Do you solemnly state the testimony you're about to give in this interview shall be the truth, the whole truth, and nothing but the truth?
I do. Good morning.
Good morning, Ms. Pierce.
So I'm going to just pretty much read off of what we have submitted submitted, and then if there's any questions. So in 2012, I was one of 3 sales representatives working out of the Northern California Roseville office. The Roseville office was a small division of McCarthy Incorporated, which consistently struggled to stay profitable. During the leaner years, we struggled to keep the office open, and it was common practice in that climate not to submit expenses for failed pursuits in order to keep the overhead low. We did not discuss this practice with each other or with the management, and it was something we adhered to despite the corporate reimbursement policy stated. And I should explain that we were an employee-owned business, so everybody had a stake in the company making it profitable, and we knew on a semi-annual basis how our office was doing in terms of our contribution to the corporate bottom line. So it was very much a environment of keeping your division or your office profitable in order to help the company along. And there were offices that had been closed because of job losses or overhead. So my goal was to do my job and to blend into the Roseville office culture. I was driven by my desire for our office to remain open so I could keep doing my job. Sales representatives were reasonably paid, so we absorbed the business expenses related to dead-end pursuits in order to keep the profit margins of the Roseville office as high as possible. I acquiesced to this business practice because I was not interested in changing the office culture, but rather to work with bringing in clients and projects and also to keep my position. And my supervisor never asked me to submit reimbursement requests for any dead-end pursuits. It was really, we were reimbursed for projects or for costs that we could, project costs, so it wouldn't come off of our overhead, but a client would pay for our hours, our driving, our travel. As a result of the respondent's audit for my 2012 tax return, I did attempt to locate my fellow sales representatives to corroborate my story, but unfortunately, one of them I couldn't locate because they had changed jobs, and the other one just wouldn't agree. Say tax appeals people start to run. So I couldn't get cooperation from my other 2 associates at the time. So contrary to what the respondent has stated, I did not intentionally discard the business documents I used to complete my 2012 tax form. But in 2013, I got married, so I moved my home into my husband's home and inadvertently got rid of my wrong boxes of my tax returns. So my supporting documents were lost and I was unable to recover them. So after the Franchise Tax Board audited me in November 24, 2015, I just used the remaining resources I had, which was essentially my overall business calendar and my credit card statements at that time, to try to recreate what I could on my expenses. So it was the only reasonable reconstruction I had at that time to do it instead of... so this is a reasonable reconstruction of my unreimbursed business expenses of 2012 because they show the name, location, amount spent on the expenses. I completed the reconstruction, sent it to the Franchise Tax Board in March 4th of 2016, which was nearly 3 years after I had submitted my 2012 tax returns. And that's about all the information I have that I was presenting. So.
Thank you, Ms. Pierce. Ms. Gonzalez, at this point, would you like to ask any additional questions of Ms. Pierce? Okay. Mr. Miller, would you like an opportunity to cross-examine the witness?
No.
At this point, I'm going to turn it over to my panel to see if either of them have any questions. Ms. Hosey?
No questions, thank you.
Mr. Leung?
No questions, thank you.
Ms. Pierce, other than what you've testified here today, is there anything else that you think this panel needs to know in order to make a well-informed decision?
I don't think so. You guys understand what my argument is.
Thank you, Ms. Pierce. At this moment, you may step down from the witness box and return to your seat. Thank you very much. At this moment, we're going to begin the argument portion of the hearing. Having concluded Ms. Pierce's testimony, we have thus concluded the evidentiary portion of the hearing. Ms. Gonzalez, you have up to 10 minutes for a closing argument. You may begin whenever you're ready.
The Franchise Tax Board points to the corporate policy of McCarthy, yet Ms. Pierce has presented to the OTA evidence that the Roosevelt office did not follow the corporate policy. Ms. Pierce provided evidence under oath that the Roosevelt office only reimbursed for business expenses that resulted from construction contracts, which differs from the McCarthy corporate reimbursement policy, which reimburses for all employee expenses. If the Roosevelt office followed the corporate reimbursement policy, we would not be here today. If the Roosevelt office followed the corporate policy, Ms. Pierce would not have flown all the way here from Montana to provide evidence that the Roosevelt office did not follow the corporate reimbursement policy. We request that reconsideration of Ms. Pierce's appeal and a finding in her favor. Thank you.
Thank you, Ms. Gonzalez. FTB, you have up to 10 minutes to make a closing argument. You may begin whenever you're ready.
Allen claims an unreimbursed employee expense deduction of $36,000. This is about 1/4 of her reported wages in 2012. Appellant's then-employer had a written policy to reimburse employee expenses that were documented and directly related to the active conduct of business, including expenses for meals and personal vehicle use. Appellant did not seek available reimbursement for meals, personal vehicle use, or other expenses. Under the law, a taxpayer must request available reimbursement to be entitled to an unreimbursed employee expense deduction. Because appellant failed to seek available reimbursement, respondent properly disallowed her claimed deduction. Appellant contends that she did not request reimbursement because she was concerned with her then-employer's financial condition and her job security. But under California law, an employee's concern for her employer's financial condition or fear of being laid off does not excuse the employee from first seeking available reimbursement from her employer. She also told us this morning that she did not discuss with her employer a curtailment of her reimbursement. Apparently this was never discussed. In Exhibit 7, a declaration she submitted with her briefs, she said that these expenses were scrutinized, which is not the same as being denied or disallowed by her employer. In conclusion, reimbursement for documented expenses directly related to the conduct of business was available from her then employer, but appellant did not seek reimbursement and is therefore, under the law, not entitled to deduct unreimbursed employee expenses. Thank you.
Thank you, Mr. Miller. Ms. Gonzalez, at this moment, you have an opportunity to make your rebuttal argument of up to 5 minutes if you wish.
Thank you. The reimbursement was not available to sales associates at the Roosevelt office. It was a practice that was observed and practiced with the other 3 sales representatives. Therefore, reimbursement for travel and meal expenses that were related to pursued clients was not available unless a construction contract was signed. This was the practice for the duration that Ms. Pierce was working for McCarthy Building Corporation. Thank you.
Thank you, Ms. Gonzalez. At this moment, I'm going to open it up to questions from the panel. Questions of either Representative Ms. Hosey?
I have no questions. Thank you so much.
Mr. Lim?
For the Franchise Tax Board, you referenced that the requirement that the expense this be reimbursed by the employer under California law must be made to the employer as a condition for, and denied by the employer as a condition for taking the deduction. Is that requirement also true on the federal return, or is it just a California requirement?
Also required on the federal return.
She did receive the deduction on her federal return, correct?
Claimed the deduction, but the IRS did not examine her 2012 return.
Any further, Mr. Lim?
No.
Okay. Bless you. FTB counsel, either of you, is there anything else either of you would like to add?
No.
Ms. Gonzalez, the appellant has the burden of proof, so I do want to give you the last word. Other than the pleadings that have been filed in this case, other than the testimony that we heard this morning from Ms. Pierce, and other than the statements and arguments that you've already made, is there anything else that you would like to say to this panel? Okay, thank you. In that case, that concludes the hearing in the appeal of Monique Renard Pierce, OTA case number 18010967. The record in this matter is now closed, and the matter is submitted as of today, November 18th, 2019. This panel will issue a written decision to the parties no later than 100 days from today. Thank you. We can now go off the record. And the next hearing will begin in approximately 10 minutes.
Mr. Sykes, would you like to come forward?
I didn't hear you.
Yeah, I didn't have my mic on the first time, sorry. Okay, would you like to call the Sykes case?
Our next case this morning is the appeal of Clovus M. Sykes, case number 181-24079.
Morning. I want to take care of some preliminary issues and just to get things straight and efficient before we go on the record in this matter. I will, for Mr. Sykes' benefit, let you know that the Office of Tax Appeals is independent from the Franchise Tax Board. We are not the same agency, and we are doing an independent review of your case today. I'm Judge Teresa Stanley, and I have with me Judge Josh Lambert and Judge Andrew Cui this morning. Will be on the panel that will be deciding this case. And although I'm facilitating the hearing, we have co-equal opportunities to be involved and make this decision. I'm going to ask for appearances, and I'll start with appellant. Your name.
Clovus M. Sykes.
Franchise Tax Board.
Mira Patel, and I'm here with Maria Brosterhouse as well.
We'll go over the issues and make sure that they are still accurate. They're the same as I had in the minutes and orders, and so we have an issue of whether the Franchise Tax Board erred in its proposed assessment for taxable year 2015, whether the late filing penalty should be abated, whether the notice and demand penalty should be abated, and whether the filing enforcement fee should be abated, whether interest should be abated, and then lastly, whether a penalty should be imposed under Revenue and Tax Code Section 19714 for maintaining a proceeding that is frivolous or groundless. Mr. Sykes, do you agree that that's what was in the minutes and orders?
Yes, ma'am.
That's correct.
Okay, and for exhibits, we talked about admitting appellants 1 through 15 with no objection, and respondents A through X with no objection. And since then, both parties have submitted a couple of additional documents. I have from Mr. Sykes, I have exhibits 16 and 17 that were between them a total of 4 pages. Ms. Patel, do you have any objections to the documents that were submitted?
No objections.
And for the Franchise Tax Board, we have exhibits, just an Exhibit Y that I put together as a 9-page exhibit that were prior Board of Equalization determinations. Mr. Sykes, do you object to those?
No, ma'am.
Okay, so when we go on the record, we're going to admit appellants exhibits 1 through 17 and respondents A through Y. They're within the same document. Okay, so next order of business. And neither side has any witnesses other than Mr. Sykes himself. Is that still accurate?
Correct.
Okay, so I think we'll go on the record now.
May I ask a question?
Oh, certainly.
Okay. In the preliminary conference, we had talked about the management of additional exhibits. There are some things that I'm going to be speaking to. It would probably be more beneficiary to everybody involved if they were to see what they are.
Are you saying you brought more exhibits today?
Well, yes, ma'am, I did.
Can you specify what those are? And as in the minutes and orders, tell me why you couldn't have got them before today?
Well, I've prepared an actual statement that I'm going to read. And there are some things that I'm going to be referencing that I've already mentioned in my original brief. So I thought that I would pull them out and just actually show them or display them as I talk about them in my statement.
Okay, and you can refer to them all you want, and I'll let you know a couple of reasons why it's not necessary to admit your statement as evidence, because you are going to give testimony, and that will be reading your message. And this nice young woman to my left will be taking down every word you say, so that'll give the Franchise Tax Board the opportunity to adequately respond to what your testimony is, instead of having additional documents that they don't know necessarily what you're referring to. They can answer what you're doing right now, today.
Sure.
Okay? And I'll let you know also that all three panel members have read the entire file. We have all of your prior briefing and the documents that you're going to refer to. We have access to them already. Okay?
Good.
All right, so we'll go on the record in the appeal of Clovus M. Sykes, case number 18124079. It's November 18th, and the time is 10:37 a.m., and we're in Sacramento, California. My name is Judge Teresa Stanley. I have Judge Josh Lambert to my right and Judge Andrew Quee to my left. And once again, for the record, Mr. Sykes, could you state and spell your name, please, for the court reporter?
Sure. Clovus, the C-L-O-V as in Victor, U.S. Last name Sykes, S-Y-K-E-S.
Franchise Tax Board?
Mira Patel, M-I-R-A, last name Patel, P-A-T-E-L. And I'm here with Maria Brosterhouse as well. Maria, M-A-R-I-A, Brosterhouse, B-R-O-H-S.
B-R-O-S-T-E-R-H-O-U-S.
Okay, thank you. This morning, we are going to admit into evidence appellants Exhibits 1 through 17 and the Franchise Tax Board's Exhibits A through Y. Are there any objections at this time to any of those exhibits? Mr. Sykes?
No.
Ms. Patel?
No objections.
Okay, and the issues are whether the Franchise Tax Board erred in its proposed assessment of tax for taxable year 2015, should the late filing penalty be abated, should the notice and demand penalty be abated, should the filing enforcement fee be abated, should interest be abated, should a penalty be imposed on appellant pursuant to Revenue and Taxation Code Section 19714 for maintaining a proceeding that is frivolous or groundless. So at this time, we're not going to do opening statements in this case because we only have one witness. So what I'm going to do is to swear you in so that you can testify, and then anything you say is going to be evidence. Okay?
Great.
All right. So do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, you had said that you needed about 20 minutes, so you can begin whenever you're ready.
Thank you. Good morning, panel. Again, my name is Clovus Sykes. For the record, I'm going to read my actual facts and circumstances. My payee status is a United States person. My state of citizenship is the state of California. My domicile has been within the state of California, USA, since 1976, where I have been permanently domiciled with no intent to abandon my domicile. My entire 2015 earnings were sourced within my California domicile, and my facts and circumstances never included either direct or indirect business connections or the performing of any services within another state of the United States or another country outside of the United States. Now, in a few minutes, Maya Patel will list a number of things she will claim that I am required to do. However, other than events that she states or indications, she will not tell you why she has chosen not to dispel the assertions in ways permitted by federal regulations that directly control this matter. If we apply the facts to the law as due process requires, Patel's assertions will bear no fruit. Nonetheless, to establish perspective, there are two court cases which provide direct guidance on managing material facts illustrated in this case. The first being a Supreme Court decision, United Dominion Industries, Inc. versus the United States, where the court rendered two quotations that I think are pertinent. When the tax gatherer puts his finger on the citizen, he must also put his finger on the law permitting. The second one, if the words are doubtful, the doubt must be resolved against the government and in favor of the taxpayer. The second case is a Ninth Circuit case, which I find extremely applicable. Is John Farley, appellant versus United States of America, where the court states, we now turn to the ground upon which we decide, no regulation. The government quotes, men must turn square corners when they deal with the government. In somewhat of a melodramatic fashion, the court continues, sure, but if the government hides the corners, what should men then do? This entire case, like prior cases brought against me, is wrought with incidents where FTB's staff attempts to hide the corners, to withhold from me pertinent factors regarding the disposition of this and prior cases. The list is endless. Royce Larson's failure to disclose the determination of my domicile status, to the liberal use of the legal term frivolous when the facts of the case do not match the prescribed criteria to support frivolousness, to the purported assertion that my actions were frivolous when the Internal Revenue Service agreed to reduce my 2010 and 2012 adjusted gross income to zero based upon facts that are present in this instant case. To the notion that my presentations to the Internal Revenue Service for calendar years 2010 and 2012 were frivolous because they were purportedly based upon defined frivolous positions that were not disclosed to me, even though I requested the information in writing. To add insult to injury, Larson states in the file notes that even though Fan had chosen two arguments from the Secretary's listing, Fan was advised by some undisclosed party to withhold from me the identified arguments. To Royce Larson's refusal to recognize under Revenue and Taxation Code Section 18622 the services 2010-2012 actions because, according to Larson, I had 60 days to appeal a notice of proposed assessment. To Brian Workin's submission of a totally inaccurate analysis regarding Treasury Decision 8734. TD 8734 was key to the Services Compliance Division's actions to reduce my gross income to zero. Again, adding insult to injury, he refused to provide to me the basis for introducing an analysis that, as a tax counsel, he should have known was untrue and could not be substantiated. The one admission that can be supported, regardless of the outcome, you will find that every step I have taken in this matter is supported in fact and governing law. However, in my quest to conduct my affairs in a manner permitted by the governing provisions, two very important facts have been acknowledged and disclosed, placed on the record, and have a direct impact upon this matter. The first acknowledged fact is documented in the transcript of case number 817237 before the Board of Equalization held July 28, 2015. I ask that you follow along with me. The issue focused on 26 United States Code 6041 as it relates to the 26 U.S. Code Chapter 61 reporting requirements. The section instructs persons who have made payments to persons to report payments in excess of $600 as specified by regulations. The term person is defined in 26 U.S. Code Section 7701A as an individual, a trust, estate, partnership, association, company, or corporation. With the exception of individual, the remaining entities are all fictitious entities. As illustrated in 26 CFR 1.1-1A, in conjunction with 26 U.S. Code 911D, an individual who is a citizen possesses within their facts and circumstances a tax home outside of the United States. Please make note of this fact because outside the United States is a key element listed in 26 CFR 1.1441-1B3 called the presumption rules. The presumption rules are the legislative elements needed to support any presumption of correctness, when, as in my case, the reporting of 1099 miscellaneous by payers is used as an indication of foreign payee status. Left unchallenged, the prima facie indication stands. The transcript on the proceedings recorded the following discourse. Page 19 at 17, Ms. Harkey speaking. Okay, now that I'm thoroughly confused, I need to know two things. I think Ms. Ma did a kind of summary of the issues before us, but this is for the department, meaning referring to either FTB staff or BOE staff. Is he, referring to me, presuming he's a non-resident alien? Is that the argument here? Is that bills? And he says no, and then Bill, he's referring to me, shaking his head no. Page 19 at 24, Sykes speaking. I can best tell you, here I was interrupted by Ms. Harkey. Page 19 at 25, Ms. Harkey speaking. Okay, what about the law in 1099 reporting? Page 19 at 27 through page 20, Mr. Working speaking. Under IRS Internal Revenue Section 6041, that he hesitates, that applies to reporting of payments in excess of $600. And he actually put this in writing, that are made to U.S. persons, which appellant, referring to me, suggests that he is a U.S. person. And I want to make note here, it must be observed that working could not then, nor cannot now, support the contention that 6041A references U.S. persons. The citation does reference persons. However, 26 U.S.C. 7701A does make distinction between persons, as we have covered, and U.S. persons found in section 7701A38. Now we continue. Page 20 at 4. Ms. Harkey, addressing me, are you admitting that you're a U.S. person? Page 20 at 6. Sykes, I'm admitting I am a U.S. person, but, again, interrupted by Ms. Harkey. Page 20 at 8, Ms. Harkey, that's all I want to know, yes or no? Page 20 at 10, Mr. Sykes, yes, ma'am, I am. In conclusion to this segment of my testimony, and for the record, my status was entered into the record for all intents and purposes regarding income taxation as a U.S. payee, as defined in 26 U.S.C. 7701A38, as a citizen or resident of the United States. Unfortunately for the procedures at hand, Working's indefensible faux pas provided obscurity to an issue that should have been settled. In no way can I be acknowledged as a U.S. payee and simultaneously an individual subject to these rules. The importance of this issue is that according to the provisions of Treasury Decision 8734, which have now been deemed as the final regulation by Treasury Decision 9658, the following procedural steps were required of each of the payers listed in the proposed assessment issued by Larson and today's Patel. The first element of responsibility states, as a general matter, a withholding agent, whether U.S. or foreign, must ascertain whether the payee is a U.S. or foreign person. Note, emphasis must be placed upon withholding agent because the third-party payers were really not withholding agents because they were not required to withhold under Chapter 3 provisions, particularly Section 1441, because, as Brian Working states, as an interpretive written piece dated 1/6/2015 that we will focus on shortly, Section 1441 should not have applied. However, the implementing regulations show that Working was only partially correct. Section 1441 and the implementing regulations apply to the extent that the implementing regulations stress the importance of distinguishing between a U.S. payee and a foreign payee as the foundational and fundamental element to apply Section 1441 as a withholding agent. Otherwise, 1441 and the regulations do not apply. The second acknowledged fact is illustrated by Royce Larson's entries into the case file notes on October 30th, 2017 at 8:24 a.m., same day at 8:36 a.m., and July 6, 18 at 9:50 a.m. Each of the entries acknowledges my status in California as a domicile, while the entry states domicile and resident in the same manner that I cannot be an individual and a U.S. payee simultaneously. As a matter of fact, I cannot be a domicile and a resident simultaneously, as a matter of fact. Now, it's widely accepted that as a government official, Mr. Larson had a duty to respond to my correspondence pieces alleging the management of this matter. However, as recorded in the record, some undisclosed party put a muzzle on Fan, frivolous and non-filing, and Larson, instructed them to not disclose information pertinent to my defense to me. I would like to exercise my right to learn the identity of the official who obstructed my due process and their basis for so doing. Nonetheless, official and direct testimony has been placed into the record by Patel's client, directly affirming my domicile status as a matter of fact. According to the decision rendered by the Board of Equalization in the matter of Stephen D. Bragg, 2003-SBE-002, there are two vital elements affirmed in and by the decision. An individual may claim only one domicile at a time. Number two, the burden of proof as to a change of domicile is on the party asserting such change. If Patel wishes to challenge the established, acknowledged, and affirmed fact that that California is my domicile, according to the BOE's decision, she has the responsibility of introducing into these proceedings factual evidence to the contrary. But let's take the guesswork out of this equation. Regardless of any attempts promoted by Patel, outside of attempting a Brian working, she is incapable of fulfilling that feat. And even if she pulls a Brian working, like Brian working, she would be incapable of supporting the assertion. The foregoing facts set the stage for the issues involving this matter. Notice in demand to file a tax return. Patel's Exhibit A is a document entitled 2015 Demand for a Tax Return. Attention is directed to the second section where I'm advised as follows. To respond to this notice, you must complete one of the following. I am given three choices, one of which states provide information that you do not have a filing requirement to file 2015 tax return, with further instructions regarding subsequent procedures. After requesting and was granted a 30-day extension, I provided my response dated 7/20/17. That document is listed as Patel's Exhibit C and referenced as appellant letter to FTB 2015. The key point is that I responded in a timely fashion. However, the verbiage of a notice of proposed assessment dated 11/27/2017 issued by Royce Larson states, we have no record of receiving your tax return or information indicating that you do not have a filing requirement. Additionally, in Patel's brief, I am advised as follows. Because appellant did not file a 2015 return or explain why a 2015 return was not required in response to the demand, respondent issued a notice of proposed assessment for the 2015 tax year on November 27, 2017. Yet Patel provides as an Exhibit C to her brief a document entitled Appellant's Letter 7/20/2017. This is the very set of documents in response to the demand that Patel states I did not file. Therefore, the reason stated in the brief as to why a notice of proposed assessment was issued has been directly self-contradicted by Patel. So we now ask the question, what was the reason for filing the notice of proposed action? As a matter of due process, stating a valid and appropriate reason for an action is a fundamental piece according to Revenue and Taxation Code Section 19133. In no case shall the determination of the deficiency be arbitrary or without foundation. Additionally, the U.S. Supreme Court in United States versus Janus states, certainly, A proof that an assessment is utterly without foundation is proof that it is arbitrary and erroneous. Accordingly, while fact, circumstances, and Royce Larson's admission regarding my domicile status precludes me from the term resident, and as prescribed in 18 CCR section 19133A1, I did respond in a timely manner by using option number 3 as illustrated and provided in the second section of the demand for tax return. Since Patel has illustrated my response as her section in her Exhibit C, Patel has contradicted the basis for issuing the notice of proposed assessment with evidence and testimony. Therefore, my status as a domicile and my adherence to the demand for tax return makes both the issuance of the notice of proposed assessment and the section 19133 penalty arbitrary and without foundation. I'm about to wrap it up, but I do want to touch on law summary, non-filer. Patel's Exhibit L, Item 1, gives very specific instructions to every individual subject to tax under the California personal income tax law, etc. But the document falls short on identifying the individuals. However, the constitutionality letter, Exhibit 16-1, provides more clarification by identifying the who that Item 1 is referencing and what commodity is used to measure the tax. The who incorporates the 3 classes of individuals: residents, non-residents, and part-year residents, that are also referred to as taxpayers, referenced by the law summary. Item 1 advises that the individuals must file a return under penalty of perjury. The jurat of 540 states, I declare that I have examined this tax return, including accompanying schedules and statements, and to the best of my knowledge and belief, it is true, correct, and complete. The document is an admission that the title, California Resident Income Tax Return, is an appropriate form. That brings us to the what is taxed in this matter. The juror states, to the best of my knowledge and belief.
Mr. Sykes, you have gone on for more than 20 minutes, so if you're close to the end, I would hope that you are at a point where you could wrap it up.
Okay, thank you. What I want to, if I may, I want to get to the part about a firm, because Patel is saying that she has affirmed the proposed assessment, which is still based upon uncooperated hearsay evidence. 5 more minutes, please. This is vital. Extends a plea to the OTA panel that they must extend to her the presumption of correctness, even though she has shown no evidence of authenticating or vetting the evidence with the parties who have first-hand knowledge. For example, the payers who reported the 1099 miscellaneous. No evidence confirming compliance or lack of compliance with the presumption rules. She's shown no evidence to disprove that she is affirming nothing more than the fact that the evidence is merely unconfirmed indication created by the payers who determined that they were withholding agents under 26 U.S. Section 1461, when in fact they would not. Now, as I understand what affirming is, the only way that she could have done what she said was to have gone to the presumption rules and specify in those rules, or from those rules, where my facts and circumstances lie. Because it says, certain payments for services A payment for services presumed to be made to a foreign person if the payee is an individual, the withholding agent does not know and have reason to know that the payee is a U.S. citizen or resident, the withholding agent does not know or have reason to know that the income or may be or is or may be effectively connected with the conduct of a trade or business within the United States, and all of the services for which the payment is made were performed by the payee outside of the United States. Now, in order for Patel to affirm that I am an individual, she first has to go through determining that this was outside the United States, that Franchise Tax Board sent me information or correspondence outside the United States, which she cannot do. Now, regarding presumption of correction, the court, there is a piece in the Internal Revenue Manual that states the court tries not to decide issues adversely to petitioner solely on the basis of the statutory presumption of correctness. To assist the court and to represent the client, the field attorney should offer all of available evidence of material facts which support respondents' determination, rebut petitioner's position, or may help the court to make a proper ruling. Respondent's counsel's obligation as a public servant is to assist the court to reach the correct result. I say that Patel has not affirmed anything. She could not have. Given the rules of the presumption of correctness in 1.1441-B3, as well as 1.1441-B3 subdivision 8, which allows me, whatever facts that she brings forward, I have the right to challenge them. This assessment cannot be approved. Thank you.
Thank you. Ms. Patel, do you have any questions?
No questions.
No questions.
No questions.
Okay, it sounds like the statement that you read was testimony and argument all wrapped into one, so I had allotted extra time, which you took for that statement,
Thank you.
For the closing statement. Is there any one thing you want to say to wrap up your final comments?
The only thing is I ask is that this be done in conjunction with the rules. I've put my facts on the table. She has not objected to them. She has not opposed them. She has not refuted them. She has not denied them. Royce Larson and the rest of the group there have put notations within the case file that notates that my status is that of a domicile. So, thank you.
Great, thank you. And Ms. Patel, would you like to present your closing argument?
Thank you.
I believe Judge Kui has a question for Franchise Tax Board before we proceed.
Yeah, I had two questions. Is this on? Can you hear me? Yeah, sorry about that. So I did have two questions. One was about Exhibits A through C, and if I understand correctly, the taxpayer was arguing that the demand penalty wasn't properly imposed because they provided a timely response. And I'm just curious, is FTB's position that the taxpayer did not provide a timely response, or is the taxpayer's position, FTB's position, that the taxpayer did provide a timely response, but the response was not in the required format, that is basically a return, and that's why the penalty was being imposed?
Yeah, so Appellant did respond, however, it wasn't in the manner prescribed. He didn't file a return or provide evidence suggesting why he did not have to file a return.
Okay, and I did have one other question, and that was on Exhibit K for the Franchise Tax Board. And it looks like you provided the IRS transcript, which indicates that the 2015 tax year was referred for further review. And my question is, do we know if there was a federal action taken on this account for the 15 year, or do we not know what's going on at this time? Is there no final action?
As of right now, there is no additional information from the IRS.
Okay, thank you.
I gave her that information. I told her specifically why there was no filing requirement.
That's okay. We do have the account transcript for that year in our file, so we can refer to that when we're making our decision. Ms. Patel, you can proceed now.
Good morning, judges. This is appellant's 7th appeal of this nature, and respondent has no record of appellant filing a valid tax return since 1995. Respondent's assessment is based on appellant's California domicile and based on miscellaneous income and retirement income reported to the Internal Revenue Service by multiple payers. They each reported that they paid income to appellant during the 2015 tax year. Based on these sources, respondent has met the initial burden to show that the proposed assessment is reasonable and rational. Appellant, however, has not met his burden and has not provided any specific, credible, or relevant evidence that he did not earn the income as reported. Appellant raises arguments that consistently have been rejected by the IRS, the federal courts, and the Board of Equalization for many years. Based on appellant's arguments and compliance history, imposing the frivolous appeal penalty may be proper, as it has been in previous appeals. Because appellant has not met his burden of establishing that respondent's assessment is incorrect by filing a return or providing other evidence to show error, respondent requests that the Office of Tax Appeals sustain the assessment. Thank you.
Name one case.
Wait, Mr. Sykes, please address the panel. That's what
sorry.
you're here for. I'm going to give you another 5 minutes if you want to respond to that briefly.
Thank you. The first thing that I want to respond to, according to the rules, if we're going by the rules, the only thing I need to show her is a W-9 with my name, address, social security number, signed under penalties of perjury. That's all I need to show her. Nothing more, nothing less. Secondly, she cannot cite one case that backs up the statement that the IRS, a franchise tax board, courts have ruled on contrary, in a manner contrary to what I've presented. She could not name one case. That's the thing about this whole brief. It's nothing but assertions. Things that look good philosophically, but no meat, no substance. The 1099s that she's utilizing, she first must admit that that stuff was not reportable. If she doesn't admit that, then justice is not being carried. Those items, because of my status, and then she said my domicile status. But then, if I were a domicile and she could file something against me, then that means that I was a domicile who was like away on some type of political appointment, as identified in 17014. All of the parameters for residency is right there in 17014. I do not meet those. She did not identify anything of the sort showing that I was away on some type of political appointment. I think it's outside the state for other than a transitory purpose. So she doesn't identify any facts, just a lot of assertions. So I will ask her, just like I've asked all the other attorneys, why can't we sit down and deal with facts? And why can't we sit down and deal with the way the rules manage those facts? That, to me, is due process. Thank you.
That concludes the hearing this morning. And so the case is now submitted for a decision, which we will mail no later than 100 days after today. Thank you for participating, and we're going to adjourn today because there are no more cases to be heard. Thank you.